All right, let's see. Looks like we hit the buttons. It's doing the stuff. Looks like it should be good. And chat's open. I always forget to do that. And that's good. All right, cool. Looks like everything's working. We're up and running. So good morning. Hope you guys are doing well. I appreciate you guys. You guys have just been so awesome, and I hope this has been helpful for you and your teams. It's been helpful for me, a little bit therapeutic as well, to kind of go through, just figure out what the heck is going on. So whether you just watch or you send a kind post or DM, I appreciate those, or maybe subscribe, or you've joined the channel. I appreciate you guys for all that you've done. So we've got a lot to cover today. I'm going to try not to run too long. Hopefully we can get it done fairly quickly. But two main points. The first one, we're going to talk about DaJuan's summons, and apparently they haven't been able to get a hold of him. He did message me and say that he's been on vacation. So if that's true, I apologize for being a little bit facetious in the post and some of those things. But, he does some funny stuff. So you kind of can't put it past him as well. So DaJuan, if I owe you an apology on that, here's my apology. So, but anyway, they've attempted to serve him like 16 times or something, and they can't find him. So whatever has happened, we'll go through that filing, and they're going to be asking the judge for help with that. And the second part we're going to be going through, this just landed as well, is going to be Olson's side of what's going on with that motion to compel. And a motion to compel is basically the attorneys saying, hey, we've been requesting this information, we're not getting it, judge, we needed you to step in. So on Wednesday, the third part we're going to talk about is a little bit how to attend on Wednesday's meeting. So they're going to be holding a live Zoom, and it's going to be in the court. So if you want to watch that, you can. I think I'm going to try to hop on live. It's at 10:30. So if you guys want to hop on, ask questions, we can kind of talk about it, but I cannot rebroadcast it. So you're going to have to hop on your own equipment and listen to it that way. I'm not allowed to rebroadcast it out for everybody to hear. So I'm going to be listening to it. If you guys want to chat about some of the stuff that's going on, it'll be interesting to see kind of what's going on. It's really the first glimpse we've had where where it's going to be public. So if you guys want to watch that, you can. I don't know what they're going to do if they can hold. Normally there's like 150 people who hop on these videos, so I don't know how they're gonna, if they're used to having 200 people watch something, I don't know. We'll see what happens. Maybe we break it and they can't do it live. I don't know. We'll find out. So anyway, let's get into the first segment, and we're gonna be talking about DaJuan and kind of going through some of the things with that. So it's been kind of interesting. Again, he said that he's been out traveling, so, but you guys can kind of see a little bit of what's going on there. Oh, let me change my pen to red. I did my best to block out his addresses and that kind of stuff, because we're going to be going through a little bit of that. So they are asking for an ex parte motion for alternative service. Ex parte just means it's only one party and the judge. So they don't really need permission from the other side to do that. So they're saying, hey, judge, can you just help us? So ex parte kind of means almost exactly what it looks like, ex parte without the other part. And they're going to be asking for alternative service. They're just going to say, hey, we've tried to deliver it to all the addresses we have 16 times, and we just can't get a hold of him. So can we find a different way to be able to serve this paperwork to him? Okay. So we'll kind of walk through most of this, that they're showing that in good cause they need help doing an alternative service. It's both reasonable and diligent. Oh, yeah. And so they're going to go through kind of the statements of facts of what's happened so far. And basically what they did is they collected the declarations from all these people who tried to deliver: John Flowers, Vincent Nguyen, I have no Omar, Dean Carroll, and so it's their collection. All these people have been trying to serve him, and they haven't been able to. So now they're going to ask the judge for help. So we can kind of see a little bit of what's going on. So on the first, so this has been going on for a little bit over 2 weeks. They tried to send it to his home in the Placerville address. That's why this is blocked out here. They said they didn't, nobody really responded there. On the second, they tried to do it at the same address. Electric gate was closed, no response. They tried it on the third, same address. that they knocked, but nobody answered. On the 4th, they tried to process as well, same address, none of that really worked. On the 5th, same thing as well. Then on the 7th, same address, no answer at the door. On the 7th again. Now this one they're trying to do at a potential office, and I guess in San Jose. I don't know if he had an office out there, but apparently it came from WFG's former address for Cofield, because normally you say like what address you want your mail and everything to go to, so I guess that one's on file somewhere. And that had been converted to GFI. However, the process server learned that this address was an address for Transamerica Financial Advisors and its affiliates, and no one answered the door. On the 7th, they also tried to process personal service in Woodland Hills, another address that they had on record for him. They spoke to a couple tenants who said they didn't know him, and while the third tenant said he was just no longer working at that location. On the 8th, they tried to process it as well at a Minnesota Avenue. I don't think that's the state Minnesota. I think it's Minnesota Avenue address. Yeah. So no one answered the door. They found the business entrance door was locked. Then on the 8th, they tried to do back at the home, the Placerville address. Then on the 8th and the 15th, they contacted for defendants and asked whether they had contact information for Cofield. And he had previously submitted a declaration in support of the positions against the motion for temporary restraining order. They responded and said they were unaware who may be representing him. So I don't know if he's going to end up with a different attorney or something, but they just haven't figured that out yet. On the 9th, they tried to send it again to that Minnesota address. On the 9th, they sent it over to this address again, or these are people actually showing up and trying to deliver it. On the 10th, back to that Placerville address, it said a woman answered the door and said Cofield no longer lived there, so maybe that was a former address. On the 14th, they attempted the service again. This one was in Los Angeles. And this is apparently in regards to his insurance and driver's licenses. So maybe that was a former address as well. On the 15th, they tried the Los Angeles one again. And then the 16th again, they tried the Los Angeles. And apparently, they just haven't been able to get through. So now what they're going to do is they're going to ask the judge for some additional help. And so they talk about some different ways that you can kind of serve people, or you can make sure that they get the correct information that they need. Since if these are no longer his addresses, it doesn't even make sense to send the mail, because that's just not going to work if he's not there anymore. So they're kind of just asking for some different ways. They go into some case study about, okay, can we serve in some different manners? Despite diligent efforts, they have not been able to contact him or confirm whether Cofield has retained any counsel. Because if he had counsel, you can also send it to the lawyers, and that would count as well. But if he doesn't have any, then again, well, how do we send this information to him? And they said that obviously the Olsons don't know. And so they're moving for an ex parte in an effort to be able to serve him. So can we serve him in some different ways? So can we send him an email, maybe an Instagram? Those would be reasonable ways to be able to send him the information that he needs, the notice. And if you guys remember, they're sending him a notice. I believe this one was summons. Basically, they want to get information from him about what's been going on. He's been very outspoken about the whole thing. He's been doing lots of marketing, so they just kind of want to figure out what he knows and, kind of how some of this stuff happened. So, and then obviously his take in it, because they've got a lot of his documents and stuff as well. So to comply with the due process, the court ordered alternative method must also be reasonably calculated under circumstances. So they're just kind of going through some different case law, and this is saying basically they were able to serve this person by email, so they're asking if they can do that. They say that he regularly communicates by email. He also used his personal Gmail address for business and has done so since his time with WFG. When he received WFG's email account on the 24th, so basically when they responded to his resignation, they sent it to this email. So they're saying that, hey, we should be able to send it there. And meanwhile, his Instagram includes a link to set up an appointment at Ethos. When you click the link, it opens to a page with an appointment for Cofield. They can be contacted at this email as well. Thus, Cofield regularly communicates by email or one or both of those emails. As a result, service by email could be effective for him. He also uses Instagram regularly, posts every few days, so they're asking if they can also maybe send it on there. He also posted on Instagram twice on March 7th and March 6th, March 1st, and the 29th, so that might be a more efficient way to be able to get a hold of him. WFG also demonstrated reasonable diligence in attempting to serve him, and they're going to use some other case law saying, look, we've tried a bunch of different ways, we've tried all the addresses we have for him, we just haven't been able to get a hold of him. So number of honest attempts to learn the defendant's whereabouts and his address, hiring processing servers to attempt to utilize public information available, speaking with neighbors, making multiple attempts. So they're basically just saying to the judge, hey, we've gone through all of these things, we've tried 16 times, and we haven't been able to at 4 different addresses at various times of the day. Moreover, WFG process servers spoke with the residents when possible to determine his whereabouts if they knew. Maybe if he had told them he was on vacation or if he had moved or whatever, so they're trying to get information from other people who might know as well. Lastly, they conducted a TransUnion report and a queryant report to determine alternative possible addresses to the effects of Cofield's. Thus, they've demonstrated reasonable diligence in attempting to serve him personally. So they haven't been able to do that. They're going to talk more about a couple other cases that allowed them to do by email in attempts to hopefully be able to do that. And so again, they're just kind of going through saying, look, we've gone through public records to find a physical address. We have not been able to find one. Moreover, Cofield uses email regularly to recruit and communicate with customers. So can we use an email? Courts have also permitted service by social media as providing actual notice. It's kind of interesting. So they're talking about some case studies here as far as being able to use social media. Moreover, courts have allowed service by email and social media where there was evidence that the parties being served regularly use those means to communicate. Courts have permitted service by social media where defendants actively use social media and refer to the lawsuit on the internet. Oh, that's interesting. So if you refer to a lawsuit on the internet, I guess that opens you, I don't know if that makes a difference or not, to being served. If you're going to talk about the lawsuit on the internet, then they can serve you on the internet. That's kind of interesting. Oh, I never even thought about that. So here, service by Instagram to Cofield would provide actual notice. Cofield constantly uses his Instagram several times per day and multiple posts per day. So they're asking if they can be able to do that as well. So kind of your thoughts on that, but this was dated the 19th, so they tried basically from the 1st to, I think the 18th was when this was posted, 17th, 18th. So tried for 2.5 weeks to be able to get all of them. They haven't been able to. So that's something that they're going to be discussing on Wednesday's meeting as well, on top of the information about the motion to compel. So that's really what we've got on that aspect of it. So I don't know your guys' thoughts, if that seems like adequate notice there. And then we're going to switch over to what's going on with Eric Olson. So if you guys remember the video from Friday, and if you haven't watched that, I think you'll still get the context from it, but basically what's happening is they're going back and forth on the information around Eric Olson and the discovery. So basically what was supposed to happen was once the judge says, hey, you can do discovery, then you're allowed to start collecting information. Because basically WFG is trying to figure out what's going on, right? They haven't been privy to a lot of the communications that are going on outside. So what they're asking for is, hey, we want phone records, or text messages, stuff that's on social media,